Today's episode is a 12-point guide to estate planning. I get it. Estate planning can be overwhelming. How are you going to organize it in such a way so you get away from that wall of overwhelm, but break it down into bite-sized pieces? That's what we're going to do today. You can pick up a piece here or there, but before you get your own planning in place, you need to consult with somebody that's going to give you a good evaluation of your entire situation. So that's my disclaimer. This podcast is entertainment. It's information. It's great information. It's critical for families to know it, but it is not legal advice. Now, let's get to the 12-point guide to estate planning. The first is defining what your goals are. What do I mean there? Well, I meet with families all the time who come in, and I think I can be sort of frustrating to meet with because many times I meet with folks who sit down across from me and say, well, all right, Jim, we've been to your workshop. We've heard you talk about estate planning. You're clearly experienced. You've worked with a lot of people. Tell us, how's this going to work for our family? And I say, tell me how you want it to work for your family. The beautiful thing about estate planning, one of the many beautiful things about estate planning, is that it is individual to each family. Off-the-shelf solutions don't very often work very well. And anything that a family wants, within reason, we can figure out how to put it in the plan. The question is it smart? Is it prudent? Is that what should happen? If the family decides that's where they want to go, we can figure out a way to do it. So that's the first step. Number one, the first point in our guide to estate planning is defining your goals. You've got to begin with setting the family's objectives. Who do you care about? How do you want things to look as time goes forward for them? The objectives, remember, cover not only who gets your stuff when you die, that's sort of the second phase of estate planning, but also you should think about goals. What happens in the event of disability? Between the day you get your plan signed and in place and the day you die, you may need help. As little as my clients like to think about death and dying, they like to think about being disabled even more. So that's important to sit with that. Consult with your loved ones, your family members. If you have a spouse, you're going to be doing planning together likely. Think about how you want that to work out. So that's number one. Number two, inventorying your assets. Once you decide how you want things to look, a big impact on that is what you've got. And that means figuring out how many bank accounts you've got. What kinds are they? Checking, savings, money market. You've got perhaps retirement assets. They might be 401ks or IRAs. If you're a business owner, you might have SEPs or Simples. They can be also 457 plans, 403B plans. Anything that's a tax advantage plan falls into that retirement category, including Roth IRAs. It's important to categorize those accounts so you understand which assets are governed by which sets of rules, because there are specific rules for those retirement assets. Inventorying your assets allows you, one, to figure out kind of a global net worth. For many of my clients, when they fill out our intake form, and my intake form, the personal information form that I use, has just a snapshot of that financial information. I'm never asking for account numbers, and I don't really need amounts to the penny. But this gives us an idea of what the family is working with. I've had so many of my clients go through that and say, you know what, I really enjoyed that process because I realized maybe we're a little bit better off than we thought we were. So number two, that's inventorying the assets. What do you have? How's it help? What type of asset is it? Are there real estate assets, vehicles? Are there collections? Sometimes there can be personal property that's a coin collection or precious metals or other kinds of collectibles, and of course, jewelry. So making sure that you understand what you've got is number two. Number three is seeking professional estate planning guidance. Why do I say that? Well, because there are a lot of kind of DUI. There are a lot of DIY solutions out there. You'll see commercials on ESPN lately from time to time. There's a couple websites that are well known. If you look through those websites that offer these legal documents, and they may even say that these documents are designed by an attorney, you'll notice that those websites have disclaimers on them that say, we're not a law firm, these websites say, and we're not a substitute for the advice of an attorney. So just like the disclaimer for this podcast, they have a disclaimer that says we're not actually practicing law here. We just offer these documents. Now, the idea of sitting down with somebody who's had some experience is not necessarily that estate planning all of its brain surgery and you couldn't figure it out. The point of sitting down with an experienced professional is that they have some experience. They can give you some guidance, and they also understand things in the law that might be contrary to common sense. Big shocker, the law and common sense are very often two different things. What you expect to happen under the law may not be what actually happens under the law. So there can be consequences that are unexpected. The best way to guard your family against that is not doing it yourself, not going alone, but consulting with somebody who's got experience in doing it. So professional guidance can help avoid those common pitfalls and tailor strategies that are specific to your family's needs. And so that is number 3, working with an experienced professional estate planning attorney. Number 4, getting a will in place. That's going to be the objective, at least in part, as we think about, again, that second phase of estate planning, who gets your stuff when you die. The will allows you to lay out a roadmap for the family so they understand what your wishes are and carry them out. Of course, with estate planning, there's 2 really primary objectives that we're addressing with estate planning. And the first is making sure that the family's got a roadmap, that they're not at a loss for what to do, that it's as easy as you can make it for them. Also, to make sure things go the way that you would have them go rather than your family making decisions that are contrary to that. So making sure that you've got a good will in place is a cornerstone to that. It's important to make sure that the wills are properly executed, that the signing ceremonies in the state you live in have been complied with, so that those wills, if at all possible, not only are effective, but are self-proving, meaning that if a will needs to go to probate, the witnesses to the will don't need to be called in to testify because the will is what's known as self-proving. It's got extra validation in it so that the court won't require hearing from the witnesses that signed the will. Just making sure that that is in place is really key. But a living trust plan has not only a trust in it, but also a will. The will in a trust plan says, hey, I did a trust. If I've died and you found something that wasn't in the trust, I want you to pour it over to the trust. In fact, they're known as pour over wills. I like that because it's visual and that helps me remember it. The wills say, hey, take whatever's in my probate estate, pour it over into the trust. But a lot of folks who are drawn to doing the living trust-based plan rather than a will-based plan are attracted because it just makes the administration of everything easier for the family. It eliminates, if funded properly, a trust plan eliminates the need for probate. That means no trip through the courthouse for the family. So that's number 5 in our 12-point guide to estate planning, is getting a living trust established if it's going to make things easier for your family. Very often it does. The exchange when you do a living trust is that you front load some of the work that an executor would need to do later. The advantage to that is you're doing it now while you're not grieving. You don't have a family who's going through a time of stress. You get to do it calmly, orderly, and then it's already done for them later and they don't have to worry about it. So trusts give a mechanism to manage the estate efficiently, making sure that your wishes are carried out just like they are in a will, but without the extra administrative steps of going through that probate process at the courthouse. So that's number 5, establishing trusts that are appropriate for your family's needs. Number 6, beneficiary designations. There are ways to stay out of probate that don't involve a trust, don't involve a will, of course, and one of those is making sure that when you can establish a beneficiary designation on an account or on an asset, that you do. What's a beneficiary designation? Well, it's just like on an insurance policy. The person who benefits when you die, that's your beneficiary on that. You also make beneficiary designations on your retirement accounts. You may recall that if you have an employer-based plan, when you started that job, you met with HR, they gave you all those documents, and who do you want to pay if something happens to you, who gets your retirement plan, and you filled all that out on day one. What's important to remember about beneficiary designations is that they are a contract, a binding agreement with the custodian of those funds. And upon your death, the custodian is going to do what you've told him to do, even if you've been divorced and remarried since then, and the original person on there is now your ex-wife or ex-husband. That contract says pay who I've written down there. It doesn't say, go check to see what my will says. The custodian is required to pay whoever you've listed. So one of the key things about beneficiary designations is making sure that they're current and they reflect what's actually going on in your life now, because sometimes they may be from a time when things were a little bit different. So beneficiary designations keep assets out of probate, so they're really important to use. If you've got beneficiaries who don't just need a lump sum. What I mean by that is that if you've got beneficiaries who need some guidelines, some guardrails, some assistance in managing the money, or if they're younger, you want to spread that out over time, or if they're too young to manage, let's say they're under 18, they're underage and they can't manage money, then beneficiary designations fall short then. That's when you need to plan for securing your children's, and we're going to put this under the category of children's inheritances, but it really applies to all your beneficiaries, and that's number 8. So number 6 is beneficiary designations, making sure they're current and they're the folks you want them to be. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestatesplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. Number 7 is planning for incapacity, making sure that you've got a good power of attorney and healthcare directive in place. In other states, the healthcare directive is broken into different pieces. And in Georgia, we used to commonly use what's known as a durable power for healthcare, a durable healthcare power of attorney. Now we've put that idea, the idea of appointing a healthcare agent, inside our advanced directive. So we've got the living will and the healthcare power of attorney together in one document, the advanced directive for healthcare. There are various versions of this in other states. You're not required to use, in Georgia, you're not required to use the state's version, but doctors and nurses in the state you live in know where to look on the state form. So that's something to be considered as you move to a new jurisdiction. If you move to a new state, move from a state, it's a good idea. I always recommend my clients, if they're moving to another state, meet with an attorney in that state that you're landing in to make sure that your healthcare directive is going to be easily digestible by doctors, nurses, and hospitals where you are. So that's really important, is to make sure that you've got a document that is accessible. That's the healthcare piece of it. Power of attorney is a way to convey legal and financial authority to somebody to act on your behalf if you need them to. One of the key things to remember about powers of attorney, and there's a whole episode in the podcast about powers of attorney, but just to reiterate, one of the really important things to remember about powers of attorney is that by executing a power of attorney, you're making a helper. You're making another set of hands, eyes, and ears to work for you, but you're not diminishing your own power. charging somebody with that authority to do legal and financial things for you doesn't reduce your ability to do for yourself. This is really key to a lot of my folks as they age. They're not ready to give up independence, but they do want the security of having a backup in place. So powers of attorney are beautiful for that. I would also say that all these incapacity documents that we're talking about really are necessary the moment somebody turns 18. None of us are promised tomorrow or what it will look like. And incapacity can strike at what seems to be a whim. Every adult needs to make sure that they've got a backup to do legal and financial things for them, and also the healthcare thing. So that's number 7, planning for incapacity. Number 8 is securing your beneficiaries' inheritance. Normally, children is what we talk about, and I referred to this when we were talking about number 6 in beneficiary designations. This is making sure that if you have beneficiaries who are underage, well, they're not going to be able to access or manage money on their own. If you make no plans for them, if it just is an outright distribution of them, whether it's through a beneficiary designation or through your will or trust, they don't get the money. Either the custodian of the money is going to hold it until they turn 18 in some administrative fashion, and the rules will be as they deem, or it will go into your estate, and a probate court will want to see a conservatorship for a minor. Conservatorship is like a guardianship, and in some states it's called a guardianship of assets or a guardianship or just a guardianship. In Georgia, we call it a conservatorship, and that's true in many states as well. That is who gets to manage the money for the minor. And that will work, but one of the big drawbacks in conservatorships is that whoever is the custodian of the money has to turn to the court every time they want to spend money that's not in the plan. They create a plan, a budget for the year. If they want to do extracurricular activity or something of that nature, they have to go back and ask the court to access the money for that purpose. I want to pay for after-school soccer. I want to pay for cheerleading. Can I get money out of the proceeds to do that? Very often it's money out of proceeds, insurance proceeds. I've had clients where the father passed away and he had thought he'd done a very generous thing. He listed his 2 kids who were elementary school age as the beneficiaries of the insurance policy. Well, despite the fact that mom survived him, the court required her to do a conservatorship. She had to file all these accountings, the budgets, and had to ask to encroach on the principal anytime she needed extra money to come out. It's a big pain in the neck, and there's a lot of extra administrative costs. And the administrative costs for that conservatorship with my client, who's the father of the children and left the money to the minors, all that administrative costs and legal fees came out of the insurance proceeds. So what the kids were getting got smaller and smaller with these fees year after year. One of my least favorite things about conservatorships for minors is that when they turn 18, basically the direction is to turn that money loose to them. Giving a substantial amount of money to an 18-year-old is a disaster waiting to happen. You'd be better off giving the money to them when they were 14. I think 14-year-olds generally have better judgment than 18-year-olds. So if how the money is going to be managed and spent is important, and it's always important when you've got minor children. It can be important with older beneficiaries as well. That's where you need to do some testamentary trust planning. Testamentary trust planning is where you lay out rules to make sure that the inheritance is distributed in a prudent way. Number 9, life insurance considerations. So we've talked about beneficiary designations, but making sure that your life insurance is adequate to cover your needs. I can't tell you how many families I've seen where somebody who seemed very healthy, a provider for the family, was cut down early. And unfortunately, very often there is not sufficient life insurance in place. Evaluating the correct amount of life insurance and how to pay for it, that's financial planning, but it's critical and something I talk to my clients about because it can make such a difference in how the family goes forward if something unexpected happens. So number 9, making sure you've got proper life insurance coverage. And a lot of folks have life insurance. If they've got kids, they get life insurance coverage enough to pay off the house and pay for college. And as the kids get older, that need for life insurance can be reduced. And so very often I see my older clients have a smaller amount of life insurance, but they've made a deliberate choice and they're very comfortable with that because as they've accumulated and as the kids have gotten on their feet, they no longer need that backup security that life insurance gives. So that's number 9. Number 10 is estate tax planning. So in Georgia, we're pretty fortunate because there is no Georgia inheritance tax or estate tax. The only thing that my clients have to worry about is the federal estate tax. Some states have estate tax, which estate taxes tax the estate. If the estate is over a certain amount, they tax the estate. Some states also have an inheritance tax. So an inheritance tax is paid by the person who receives the inheritance. So it can be 2 kinds of taxes. In Georgia, we have neither of those. The federal tax is an estate tax. It's taxed to the giver. And it's part of that unified credit that covers gifts that we make during lifetime and also what we leave in our taxable estate when we die. The good news is that the estate tax threshold is set to a level right now that it affects far less than 1 out of every 1,000 Americans. It's set at $15 million per person and $30 million for a couple. And there's a very easy mechanism to make sure that spouses get the full amount of that through what's known as portability. We're not going to talk a lot about that today, but suffice it to say that estate tax planning has gotten easier for most folks. If estate tax planning is an issue for you, first of all, that's a good problem to have. Second of all, there is a lot of planning that was developed when the estate tax threshold was much lower than it is today. All that planning still holds. There are charitable remainder trust, charitable lead trust, there are spousal limited access trusts, there are a number of different techniques that can be used. Irrevocable life insurance trusts, I'm missing some, but there are a number of different trust mechanisms that can be used to manage an estate tax issue to make sure that you've got tax efficiency, that you pay not more tax than you need to. So that's number 10, estate tax planning. Number 11, digital estate planning. Digital estate planning, making sure that your agents, whether it's an executor under your will or a trustee under your trust, making sure that they've got the authority to manage your digital assets. You need to make sure that this is covered not just in your trust and will, but also in your power of attorney. And most states have adopted some form. There's a uniform code for digital assets. Not every state has adopted the uniform code, but it is a uniform model code. But every state has some form of digital assets. You need to make digital assets powers that can be granted to agents. And so you need to cover that in 2 phases. One is during disability through powers of attorney, and also at death to make sure that your digital assets are handled appropriately. Whether it's social media, whether it's your business's social media, whether it's LinkedIn, Facebook, Instagram, any of those accounts. So that's number 11, digital estate planning. And finally, number 12, we're finally there. It's the 12th point of our 12-point guide to estate planning. That's reviewing and updating your estate plan. More than half of people don't have an estate plan in place, so you're doing well if you've got one. But once you've got one, it's not really a set and forget it. Estate plan documents don't expire. They don't have a shelf life. They don't go bad after a certain amount of time. However, what can happen is that documents fall out of sync with what's going on in the family. And it can be because of change in members of the family. You might have new in-laws. You might have folks that used to be in-laws that aren't anymore. It can be grandchildren or children that have been born. You can have folks who have become ill and now they have special needs planning that needs to be addressed. The assets of the family may have grown. The assets of the family may have gotten smaller. It's important to review and update the estate plan to make sure that over time it stays in sync with what's going on in the family. Just like off-the-shelf planning doesn't work for every family, generally what a family did 15, 20 years ago, even 10 years ago, may not fit very well now. So that's where it's worth a consultation. Getting back to our prior point about working with a program that we call the Little Red Wagon Club, the Little Red Wagon Club, so that those folks, if they wish, can be a member of that. And we send them a summary of their plan every year along with a questionnaire, walking through several points to see if there's been any change that would require a consultation to do that. Folks that are on our plan, they don't have to pay for consultation fees and those sorts of things. And if their family does additional planning, we give them a discount. But the most important thing to me about the maintenance plan, our Little Red Wagon Club, is that for those folks, if there's a change in the law that impacts their existing documents, we commit to go ahead and update those to comply with the law as part of our obligation under the maintenance plan. So reviewing and updating your estate plan, if you want to figure, I would say at least every 5 years. As you get over 50, I would say probably every 3 years and maybe even every year, just to make sure that everything is in place, particularly if you have a larger estate. If you have a family-owned business or significant business assets, that's important to keep up with as well, because there can be many phases of the law that have even just small adjustments that may merit coming back to make some changes in your plan, just some tweaking to make sure that your plan stays in sync with what's going on, not only in your family, but also with the law. Because remember, the law and common sense, not always the same thing. Sometimes you think, well, they're not ever the same thing, but that's important just to keep in mind. That's our 12-point. We've gotten through the 12-point guide. 1, defining your goals in estate planning. 2, inventorying your assets, making sure you know what you've got. 3, working with professional estate planner to make sure that you're covering the bases as you need to. 4, making sure you've got a good will in place. If it's carrying the whole load, it's going to be more elaborate. If it's a pour-over will, that's because, number 5, you've established trusts that are appropriate for your family's plan. Number 6 is making sure that beneficiary designations are all made when you can and that they're appropriate. And those beneficiary designations can be people or they can be to the trust. It depends on what your beneficiary's needs are and how you need to work through that. Number 7, planning for incapacity, making sure you've got those first 2 legs of the stool of estate planning put in place, and that's your power of attorney and your healthcare directive. Number 8, securing children's inheritances, making sure that they've got testamentary trust planning in place so that their inheritance is governed the way you want it to be, not the way state law says that it has to be. Number 9, making sure that you've got appropriate life insurance coverage that is in place and designated properly to fund your plan and your family's needs. Number 10, estate tax planning. If you have a larger estate, this can be critical and can make a large difference for the way the inheritance is distributed and how much goes to pay taxes. Number 11, digital estate planning, making sure that your agents have access and instructions with your digital assets, not just when you die, but also should you become disabled. So it's covered both in the disability documents and also in the distribution documents when you die. Finally, number 12, reviewing and updating your estate plan. Thanks for sticking with me through these 12 points of estate planning. Like I say, I dream of a world where everybody's got their estate plan in place so that families can spend time together instead of figuring out how to do a bunch of administrative stuff when people die or become disabled. And your kids know that you're capable. They know that you're curious. They know that you're gathering information. And if you don't do a good job, they're going to wonder why in the world didn't you? And the best way to make sure that you do is to consult with an experienced estate planning attorney. If you want more information, best thing to do is to attend one of my workshops. We have both live webinars. We've got a recorded webinar. And if you're in the Atlanta area, please come to a live workshop. I'd love to meet you. And so glad that you've taken time to gather this information today for your family about estate planning. This podcast is Let's Talk Estate Planning. You can follow us on YouTube or wherever you get your podcasts. My name is Jim Miskell. I've been an attorney in the state of Georgia for more than 30 years. All I do is estate planning, estate administration, trust administration, and probate. Let's Talk Estate Planning is not just the name of this podcast. It is also our URL for the website for my firm. If you have more questions, as I said, join us for a workshop. To get more information about when and where those occur, go to our website. If you have any questions, let us know what those are, and we'll be addressing those from time to time in question and answer episodes. Thank you again for joining me. I look forward to seeing you at a workshop soon. Take care.